What happens if during trial the defense brings up a topic that he's been told is off limits, but now he's gotten that information out and the jury has heard it? What happens then? You want to know the answer? Come join me for a minute as I share with you some great information about the answer to that question. Hi everybody, I'm Gerry Oginski. I'm a New York medical malpractice and personal injury attorney. Now look at this rock formation. This is a volcanic rock formation, and I'm here on a deserted island in St. Martin, known as Coralita Beach. Coralita Beach is all the way back in the distance there. My wife and I trekked across here to this deserted island. Why? Because she loves to pick seashells. So while she's picking seashells, I have a few minutes to share this great information with you. And now it looks like a movie set. This is remarkable. All right, but it's actually the only place I have shade and is protected from wind, so I get good audio. All right, so let's get right to it. The judge tells the defense attorney, under no circumstance are you to talk about this particular topic. And the defense attorney says, okay, judge, no problem. I won't talk about it. But now, during the course of questioning one of my experts, now the defense attorney does something he was told not to do. What does he do? He now asks my expert about this particular topic. And what do? I have no choice but to jump up out of my seat, yell out, objection, judge! You told the defense attorney he was not permitted to talk about that. That's got nothing to do with the issues in this case or the defenses in this case. Now, what does the judge do in that instance? The judge has already told the attorney not to talk about this. The defense attorney clearly and intentionally brings that subject up. Why? Because he wants the jury to hear about this. And it is damaging information. Now the jury has heard it. What does the judge do in that instance? The judge gives the jury an instruction. And he says, ladies and gentlemen, you are to disregard that question and that answer. Now, how can you disregard a question that you've just heard and an answer that the witness just gave? Can you just delete it, press delete in your brain, say, okay, the question was never asked, the answer was never given, let's move on? No, that's not how it works. And the defense attorney knows full well that's not how it works. And the judge knows that's not how it works. And sometimes he will ask a question to which he knows is improper and should not be asked. But he wants the jury to hear the question and hopefully get an answer before the judge makes a ruling about whether or not he can answer that question. So again, what effect does this have on the jury's evaluation of your particular case? If the jury comes back with a verdict against you, how do we know that that question and answer is not the determining factor that caused the jury to reach their conclusion against you? The fact is that we don't. But what we do know is that the judge told them, don't go there. Now the attorney actually went ahead and went there. And that information is prejudicial. And now the jury comes back with a verdict against you. Now we add up all the dots, we connect the dots together, and ultimately we'll have to go to the appellate court and say, listen, we believe that it is because this defense attorney went ahead and asked questions that he was told not to ask. Now the jury has information that they never should have had in order to properly evaluate this case. And because they now have this information, we believe that that has caused the jury to give us an improper verdict. Now the appellate court will have to determine whether or not that's true, whether there is reversible error. They will first look to see whether the judge gave a curative instruction. Now what's that? It's basically an instruction that tells the jury, listen, you are to disregard the question and you are to disregard the answer. It should play no part in your deliberations. But let's get back to a more practical point. If somebody has heard something they shouldn't have had, you can't unring the bell. So if you've heard a bell ring, you can't tell someone, hey, listen, I want you to forget about the fact that this bell rang. Just put it out of your mind. No, you can't do that. And that's why some attorneys will try and get out information. They will risk having the judge yell at them. They will risk having this case overturned, all because they said something they shouldn't have. So how does this affect you, and why does this matter to you? It matters to you because if you bring a lawsuit, let's say against a careless doctor or a careless driver or a careless property owner, and you suffered significant harm and injury and your case goes all the way to trial. Now, if the defense attorney says something that's improper, and the judge fails to give a curative instruction to tell the jury, put that out of your mind, well, that may be grounds for appeal. That may be grounds to overturn the verdict. And even if he did tell the jury to ignore and disregard the question and the answer, it still may be grounds to appeal and may be grounds to overturn your verdict. You know, I realize you're likely watching this video because you wanted to see the beautiful scenery where I'm shooting video today. Or you may wanted to learn how these types of cases work in New York. You know, I recognize you likely have questions or concerns about your own matter. Well, if your matter did happen in New York and you have not yet started a lawsuit but are thinking of doing so and still have questions that need to be answered, what I invite you to do is pick up the phone and call me. You know I answer questions like yours every single day, and I'd love to talk to you. You can reach me at 516-487-8207 or by email at Gerry, Gerry, at Oginski-law.com. That's it for today's video. I'm Gerry Oginski. Have a wonderful day.